Right, let's get started. It's 2:05. Thank you all for coming to this latest in the series of Cornerstone Barristers webinars that we're having in this strange time of coronavirus. And today we're dealing with disrepair litigation. In these changing times, they're changing for two reasons. There's some new law, and of course, coronavirus poses new challenges. Disrepair litigation, recently described on Twitter as the pot noodle of housing litigation. But we think today we've got a smorgasbord of substantial food for you. We're going to start off with Rowan giving you an overview of the traditional Section 11 disrepair litigation. I know for some of you that's going to be something that you're very familiar with, but bear with us. After that, we get on to the new stuff, the fitness for human habitations. Then Rowan is going to update you on the current procedural changes, the new pre-action protocol in particular. And then at the end of it, we're going to talk about how to just work with things in the current situation of coronavirus. So without further ado, I'm going to pass you over to Rowan to tell you all about Section 11 disrepair.
Thank you very much, Catherine, and thank you everyone for joining this afternoon. I'm going to provide an overview of the law.
Yep. Rowan, you're muted at the moment.
I don't know if I am. Can you hear me? Can you hear me?
I can hear you now, yes.
Okay, great, sorry. So an overview of the law relating to Section 11. It's the basis of most of the classic disrepair claims, so understanding it's an essential foundation for those claims. I can see from the attendee list, and Catherine's just said that lots of you will be very familiar with this topic, and others will welcome an introduction or a refresher. With that in mind, this section has been designed so that all levels of experience can hopefully take something away. Starting with an overview, disrepair claims can appear complicated factually and legally. Anyone's reviewed repair records or the law in this area will know that things can get confusing relatively swiftly. But disrepair claims boil down to just a few elements, and they're on screen there. One, there must be a property the landlord is obliged to keep in a state of disrepair. Two, part of that property must have fallen into disrepair. Three, the landlord must be put on notice of the disrepair. And finally, the landlord must have failed to repair the property within a reasonable period of time. Approaching disrepair claims, advices and drafting with that essential structure in mind is quite a useful tool to help you keep perspective, especially when there's a lot of detail. So next slide, please, Catherine. So where does all this come from? What's the source of the landlord obligations? Obviously today I'm talking about Section 11, which implies a suite of obligations into most residential tenancies. And I say most, but not all, and you'll have to look at Section 12 to 15 of the Act to check, but you'll see that Section 11 applies to all residential tenancies of a term under 7 years. But before you turn to Section 11, you must check the drafting of your tenancy agreement in the case that you're dealing with. The terms of that agreement may well go far beyond the terms normally included in Section 11. And you've got the case of Welsh and Greenwich there, in which there was an express obligation on a landlord to keep the property in good condition, which the court held to be different to the covenant to keep the property in a state of repair. But today is about Section 11. Next one, please, Catherine, which is appropriately titled Repairing Obligations in Short Leases. And you've got the full terms there on screen, but in overview, a landlord has an obligation to keep in repair the structure and exterior of the dwelling house. It's got an obligation to keep in repair and proper working order the installations in the dwelling house for the supply of water, gas, electricity and sanitation, and to keep in repair and proper working order the installations for space heating and heating water. That seems relatively straightforward, and I know some of you will be very familiar with that, but we'll return to the areas mentioned above in due course. Next slide, please. It's worth mentioning those obligations will apply throughout the whole tenancy. And it also means, you see the case there of Proudfoot and Hart, that any disrepair should be put right at the outset of the tenancy. But perhaps the more fundamental question is, what does repair actually mean? Next slide, please. And the answer, perhaps somewhat unhelpfully in the textbooks, which are slightly glib, they explain that it's the opposite of repair. That might appear a bit of an obstructive answer, but really, if you look at it further, it's not. It means that something's deteriorated. There must be something in the property which is in a worse condition than it was at some earlier time. You see some case law on that on screen. Now, that worse condition can't be very minor. It's got to be of substance. And of course, whether it's substantial enough to amount to disrepair is a matter of fact and degree. But Lord Denning provided a relatively useful overview in the case of Morecambe and Campbell Johnson. And perhaps it's the last bit that's the most useful. It's got to be something that's become dilapidated, worn out. It's not an improvement, something dilapidated or worn out, albeit that is a replacement by its modern equivalent. It becomes in the category of repairs and not improvements. And you'll see again on the next slide, there's another way of explaining it by Lord Sachs, who encourages you to look at the particular building, look at the state it's in, the date of the lease, look at the precise terms of the lease, we've already touched on that, and then come to a conclusion whether, on a fair interpretation of those terms, the requisite work can fairly be called disrepair. Now, next slide, please. If it follows from the definition of disrepair as something which has deteriorated, that the landlord will not be liable for everything which is substandard in a particular property. Some of these issues will not arise because the property has got worse in some manner. They'll be because the property has been poorly designed or poorly constructed in the first place. And it follows that under Section 11, a landlord will not be liable for what we're calling here inherent defects. And there's a useful case of Stent and Monmouth, the Court of Appeal, in which the front door to the property didn't have weatherboarding, and that permitted rain to enter into the building. The landlord was found not to be liable under Section 11 because the door had always been defective in that respect. It hadn't deteriorated. So that wasn't technically a disrepair claim. But it's possible the landlord may be required to remedy an inherent defect. In Stent and Monmouth, the rainwater penetration caused the door itself to deteriorate, and the tenancy agreement included a term for the landlord to keep the door in repair. So the landlord was required to therefore repair the door, and the court ordered that the landlord do so in a manner that future rainwater penetration did not occur. So in effect, the court required the landlord to remedy the inherent defect. And that makes sense, I think, from a practical perspective. If the root cause of some damage to the property arises as a result of an inherent defect, the underlying issue should be addressed, otherwise it's just going to cause the same damage again and again. And you see the property, the case of Ravenscroft Properties, Davstone Holdings there. So disrepair is effectively a deterioration and not an inherent defect. But does that mean that a landlord will be required to undertake all work requested of it? No. Whether what is requested is a repair or something wholly different from that which was let to the tenant in the first place is a matter of fact and degree. And the landlord should consider in determining whether something is actually a repair, the price of the work, what it fundamentally entails, and whether or not the work is too costly, too extensive, will depend on what work is required, obviously the cost, and how long it would prolong the life of the dwelling. Some examples of the works that have been found to be too costly or too expensive to be a repair include total replacement of foundations, replacement of all cladding to a high-rise building, or the installation of a damp-proof course. And there's some guidance from Lord Mustill in McGougle and Easington. He asks the court to look to whether the alterations, they go to the whole or substantially the whole of the structure or only to a subsidiary part of it, to also consider whether the alterations would amount to producing a building of a different character, and to consider effectively the cost of the works. I want to pause there to note that when conducting repairs, there's also an obligation on the landlord to make good or redecorate completion of repair works. Of course, that's only relevant to whatever it is that you're actually repairing. You don't have to replace an entire kitchen. Next slide, please, Catherine. On to standard of repair required. One relevant factor to whether there's disrepair at the property is the property itself. And determining the standard of repair at the property, the landlord should consider the age, the character, and the prospective life of any dwelling. And that's found at section 11.3 of the Act. For example, there's a case, Bontoya and Hackney, in which the court found that twisting of doors at the property were in keeping with the age and the type of the property, and so that twisting didn't amount to disrepair. Perhaps the other side of the phrase standard of repair is the performance of the repairs themselves. And you'll note that when performing the repairs, a landlord can do so in whichever way is going to be the least onerous for him. Can choose the cheapest option if he desires, and in that sense, the landlord is simply remedying deterioration present in the flat and not providing a different superior property to that contemplated in the tenancy agreement. If the repair requires the replacement of installations or fittings, that obligation is to replace on a like-for-like basis or a nearest equivalent basis, and there's no requirement for a landlord to upgrade fittings to bring them in line with current standards, subject to, of course, safety that might be set out in any specific relevant legislation or regulations. So, having explained what disrepair is and what it isn't, now turn to the areas of the property that the landlord's obligation attaches to. So first, on section 11.1a, the structure and exterior. Structure is helpfully set out in Irvine's estate and Moran as elements of the overall dwelling house which give it its essential appearance, stability and shape. And similarly, exterior doesn't require too much elaboration, being the outside, external part of the dwelling house, including all outside parts of the dwelling that have been let to the tenant. So some examples might include plaster, walls and cement rendering the roof, the path and steps leading up to the house, external joinery and substantial and integral windows that will be part of the structure. Turning then to sections 11.1b and c. There are a number obviously set out in the body of the statute itself. So such named installations for the supply of water, gas, electricity, sanitation include basins, sinks, baths, for example. Now, these will usually have to be within the tenant's dwelling, but some tenants experience problems in relation to the failure of installations which service a number of flats which might be outside the dwelling. And I'm thinking here specifically about boilers in a block of flats which might be housed outside their homes. The question falls whether they are included within section 11. I know this is a matter that's come up relatively recently in my practice. The answer, it's a bit of a lawyer's answer, is maybe. If the tenancy is granted after the 15th of January 1989, there is an obligation to repair and keep in working order, which extends to installations which are either directly or indirectly serving the dwelling and are owned or under the control of the landlord. And you should look to section 11.1a(b) if that's a point that arises in a case in front of you. I pause to note here that condensation is a relatively useful indicator of what amounts to disrepair. Condensation, as I'm sure you know, is usually caused by imbalances in ventilation, installations and heating. And these are classically not matters relating to the structure or an exterior of property. So the useful starting point there is that there appears to be, or on the face of it, or relatively little use for section 11 in a case involving compensation, unless there's some damage to the structural or exterior of the property that is causing the condensation, for example, by affecting normal ventilation in the dwelling. And I know this is a point that's affected by what Catherine has to say next, so I think she's probably going to provide slightly more detail on that point. Finally, can you exclude section 11? There's a relatively short answer to that question, which is no. And you'll see the case of Irvine's estate and Morgan deals with that, and section 12.1a and section 11.4. The next matter that we should deal with in relation to disrepair is that notice. So a landlord's not, unsurprisingly, a landlord's not liable to carry out repairs until he or she has been put on notice of the need for disrepair and has failed to carry out the repair within a reasonable time period. Usually, of course, notice will be provided by a tenant by direct complaint, but landlords can also have knowledge through an agent. someone who's attended the property on his behalf. And the burden of demonstrating that notice has been provided lies with the tenant themselves. There's no requirement that you particular form of complaint. It's simply necessary that you lodge, or a complaint is lodged. One addendum to that section is that notice is not required for defects outside demised premises. So after you've provided notice, or notice has been provided to you, the tenant's got to give a landlord a reasonable period of time to undertake the repairs. That makes sense. You can't be found to be responsible for not having fixed something if it hasn't been brought to your attention. So the question falls, what is a reasonable time? And there's no, again, helpfully, there's no prescribed statutory definition, and it'll depend on the facts of each case. We have got
Rowan, we seem to have lost you. Right. I think we're... Can somebody just sort of say on the quick Q&A that they can hear me? Oh, Rowan, there you are. Right, good. Rowan, we lost you in the middle of this slide. Are you... is there anything that you want to add to what was said at that point? Or should we just move on? Good, everyone can hear me. Excellent. Right, so at this point I was going to say, at this point I would be asking everybody if they had Rowan, any questions for Rowan. Obviously a lot of you have already found the Q&A and have sent in some questions. These are in addition to the ones that you've kindly sent before the seminar started. We'll try and answer these at the end as and when. I will try and weave some of these into the session that I'm about to start now, which is on the new law about fitness for human habitation. So this is the biggest change in disrepair litigation in ages, in my life at any rate, and it's exciting to have something to talk to you about for once. This is something that is going to change very much the scenarios that we have to deal with, because as Rowan was telling you, the landlord's obligations under Section 11 are limited to repair and not improve, and we've talked about condensation dampness in the past. That's always been something that we've said that's not the landlord's obligation. Maybe it falls under Section 82 Environmental Protection Act. When it comes to Section 11 disrepair, go away. All these things may be about to change. Historically, there's been an implied term that furnished premises should be fit for human habitation, free from vermin, but there was no implied term that the landlord would have to keep the premises fit for human habitation, FFHH, in the course of this. It should be reasonably healthy, it was said as long ago as 1877, not dangerous to the life of those inhabiting it. There is an implied term that premises being built will be fit for human habitation on completion. And over time, we've got various attempts of bringing the fitness for human habitation into basically claims against local authorities in particular. And in Ratcliffe and Sandwell, which others of you know as Lee and Leeds, but I was for Sandwell, so I always call it Ratcliffe, the tenant argued that the Human Rights Act meant that there should be an implied term that the property was fit for human habitation. And the Court of Appeal rejected that. They said there's not to say there'll never be cases in which a local authority will be in breach of the duty inherent for respect for private and family life, Article 8 of the European Convention on Human Rights, as you will all recognise. But that was not that case. It was condensation dampness. It wasn't anything particularly out of the normal. So the Court of Appeal left the door slightly ajar for human rights, but there wasn't that much of a crack. We already had, in the Landlord and Tenant Act 1985, Section 8, which implied terms as to fitness for human habitation, just as Section 11 implies terms as to disrepair into a tenancy. Section 8 implied terms as to fitness for human habitation. So it was implied that there would be a condition that the house is fit for human habitation at the commencement of the tenancy, and an undertaking that the house will be kept by the landlord fit for human habitation during the tenancy. But by the time we're talking about when the Act was updated, there was basically nothing that it applied to. It applied to rents of like £40 per annum. And it was quite amusing, sometimes people pleading Section 8 and relying on it, only to be told that the £40 was not per week as they believed, but per annum. They go, oh, nobody's that low. So it was pretty much empty letter. As the Law Commission report said in 1996, the right of civil remedy for tenants against their landlords in cases of unfitness had been allowed to wither on the vine. There were various attempts to get new legislation into force, but it wasn't until the hideous events of Grenfell that this gained cross-party support. Government decided to support amendments brought in by people like Karen Buck MP, with the support of Helper and Shelter. And when we thought about what had happened in Grenfell, nobody was really going to argue against that. So we now have a bit of a schizophrenic thing, because we've got Section 8 in the old terms, just applies to Wales, but we've got a new Section 9A, which applies in England. Nothing in Section 9A adds any requirements on the landlord to do works which are required because of the tenant's failure to use the property in a tenant-like manner, or because of the tenant's own breach of covenant. And it does include all the common parts in, say, a block of flats, communal areas, and things like that. But it is in the same terms as Section 8 was. So you've got the bits that I've highlighted in red, a condition that the house is fit for human habitation at the start of the tenancy, and then an ongoing undertaking that it will be kept fit for human habitation during the tenancy. And so this Act came into force on the 20th of March 2019 as an amendment to the Landlord and Tenant Act 1985. It applies to all secure tenancies and assured tenancies. It includes introductory tenancies, and it applies as to any tenancy granted on or after the 20th of March, as from the start of the tenancy, and to existing tenancies as from the 20th of March 2020. Doesn't have retroactive effect, so it sort of says that the property must be fit for human habitation as at the 20th of March 2020 and ongoing. Doesn't apply to any tenancies that had already expired between 20th of March 19 and 20th of March 2020. So all your properties should now be subject to this unless you let on leases longer than 7 years. 20th of March 2020, therefore, was a big day in housing law. Unfortunately, of course, at that time, we all, as a country, had other things to think about, and so it went slightly under the radar. So what does it actually mean? Section 10 is the definition of fitness for human habitation. It's the old legislation, so it's the old test that used to apply to Section 8 as unamended, but it has been updated. So in determining whether a house is fit or unfit for human habitation, you have to have regards to, so you have to look at these matters: repair, generally speaking, stability, whether it's going to fall down on you, freedom from damp, the internal arrangement. That might be an interesting one to talk about. Remember back in the olden days in Birmingham, I remember arguing about whether a property that didn't have a wash hand basin in the downstairs toilet was unfit because you've got the cross-contamination. And of course, when we're talking about contamination these days, we all think about coronavirus again. Lighting, ventilation, water supply, drainage, sanitary conveniences, all those things are fairly obvious. And then what's been added is prescribed hazards. I'll come back to prescribed hazards in a moment. So the house is only regarded as unfit for human habitation if and only if it's so far defective in one of those matters or more of those matters that it is not reasonably suitable for occupation as it stands in that condition. So you have to have one of those matters, and then it falls so far below the standards that you're expecting that it's not reasonably suitable for occupation. So the prescribed hazards cross refers to the Housing Health and Safety Regulation Scheme, Section 2 of the Housing Act 2004. The HHSRS says things like, will it be hazardous to potential occupiers? That's struck out for the purposes of Section 9A. But this is what we mean, a Category 1 hazard or a Category 2 hazard. These are risks of harm to the health and safety of an actual occupier of a dwelling, which arises from a deficiency in the dwelling due to the problems that we're talking about. And harm to the health or safety includes not just risk of injury, but harm to the mental health, being kept awake, asthma, all those sorts of things. And the HHSRS works by thinking one figure for the seriousness of the hazard, one figure for the likeliness it will occur, times them up. So you may have something that is really serious if it happens, but is very unlikely to happen, or you may have something that's not so serious, but it's quite likely to happen. The latter of those is likely to give you a more serious hazard rating. So hazard Category 1 hazard is the things that we're particularly looking at. And these are serious incidents. These are examples that I've nicked from the shelter website, but they include obviously dangerous wiring, something if you stick your finger in it, it'll electrocute you. There's a good chance that you'll sort of catch those wires. Dangerous or broken boilers, not just because they might have carbon monoxide coming out of them, but also because not being able to heat your house is bad for you. Leaking roof, mould, rats, vermin. Broken steps, you could fall down and break your neck. And lack of security. This is Shelter's suggestion, because people might break in and there's a risk to your health and safety as a result of that. So this is the kind of thing that poses a serious threat to the health and safety of people living in or visiting the home. So as I said earlier, you need to find the two things, not just the fact that there's a deficiency and it makes it not reasonably suitable for occupation. What does reasonably suitable for occupation mean? Going back in history again, we've got various cases where you remember I told you at the outset about the implied term, common law, about fitness for human habitation, that they've explained this. This was a case where the walls are so dilapidated that it was unsafe to reside in it. Basically, at the bottom of this slide, you will see the tenant was justified in walking out and not paying rent because he was getting no beneficial use or occupation of the premises. Paid his rent, didn't get anything for it, didn't get anything worth paying rent for. Here's another case, Smith and Marrable. It was greatly infested by bugs and as a result was so intolerable as to render it impossible that the tenant could live in it with any reasonable comfort. Hussein and Mailman coming a bit more up to date, the test was said that there was real hardship as a result of the breach. And again, the tenants were deprived of an essential part of what they'd contracted for. They weren't getting their money's worth. Ahmed and Murphy, 2010, gives us a real guideline to the standard that we're looking at. So this is a property let in 1974. And there were no facilities for cooking, the ceilings were in disrepair, damp, hot water supply was lacking, decorating the common parts. So the landlord wasn't obliged to install central heating, they found in 2010, but there were things that had to be dealt with. Condensation. There was really bad condensation and water penetration in the property. And at the bottom of this slide again, you get the judge's conclusion. By modern standards, the house was, in winter, when the condensation was at its worst, virtually unfit for human habitation. So modern standards, 1974 might have been all right, but by 2010 we expect a higher standard. Here we are in 2020, do we perhaps expect an even higher standard today? And look at the fact they said it was in winter, it was unfit for human habitation. A property might be fit in winter, not in summer. And so what we see here is condensation dampness really coming into play. As I said at the outset, we've been looking historically at saying that's not Section 11, that's not the landlord's obligation. When it's condensation dampness, makes it unfit for human habitation, condensation dampness comes back into play. So the landlord does have defences, and the first of those defences is the breach of the lessee's correlative duty to use the premises in a tenant-like manner. Now, there are other defences which include being destroyed by firestorm or flood, or, and consent of a superior landlord's not often going to come up. But the tenant-like manner is, I think, where the battlegrounds are going to be drawn. Historically, we've said that it's the job of a tenant to do those little jobs around the house that an ordinary tenant would do. Changing light bulbs is one. Lord Denning gave the example back in Lord Denning's day of cleaning the chimneys. Now, I don't think you'd expect your tenant these days to clean the chimneys, although I can tell you it's quite a fun thing to do, actually, having been able to do that myself, big brush. But I'm not recommending that you hold your tenants to that standard. What I do think is that a tenant-like use of the property includes keeping it ventilated, keeping it heated, so you don't get condensation dampness building up, not drying your clothes over the radiators, all those sorts of things, opening the windows after you've had a shower, using ventilators and extractor fans when they're installed, regardless of the running cost. And you will find that this is where we are going to have litigation, I think, to sort out whose fault it is that the property is affected by condensation dampness. Going to be difficult. Another thing that a tenant-like user of the property amounts to is allowing access to the property for the landlord to inspect, carry out repairs, do the things that a tenant may be required to do. Express terms of the tenancy might be a good idea to look at the terms of your tenancies and update them and see where we can get back to setting things out in clear terms so that a tenant knows what they've got to do. I know some landlords give guidance in terms of property handbooks. I think that's a really good idea. So this is where I see litigation unrolling in future. And in terms of access, a new section 9A7 has been written into the Act. So there's a new implied covenant by the lessee that the lessor or any person authorised in writing may enter the dwelling for the purpose of viewing its condition and state of repair at any reasonable time of the day, but on giving 24 hours notice to the tenant. And the one thing I always say in every lecture I give about disrepair is keep records of when you give that notice, how you give that notice, and what the response is when you try and get access. Now, that is the update on the standard of the law, which is fairly easy to tell from the existing case law. Quantum, because I've said that it's basically the case where you're not getting anything for your money, it's likely to be 95, 100% of the rent. If it's not the sort of case where you think, well, they should get all their rent money back, then it's not likely to be unfit for human habitation. The corollary of that is that where you've got, say, condensation dampness that may build up because of an inherent defect in the property, but also because the tenant's not using it properly, you might have, say, a 50-50 or 60-40 split, and so damages might be reduced on that basis. And obviously this leads to litigation. And Rowan is hopefully back. Are you there, Rowan? No, can't hear Rowan. What I will do is just have a quick look at all the questions that have been coming in. Oh, interesting one on soundproofing. Yes, if there's an inherent issue with the lack of soundproofing between upstairs and downstairs flats, downstairs tenant says she's kept awake at night, lack of sleep can amount to lack of health and well-being, and so that can be something that they can require you to remedy under that. And in relation to installations outside a unit, I think Rowan's answered that one. I'm not getting Rowan back at all on this one, so what I will do is scroll forward to my own next set of slides and talk about disrepair working practices in the corona period, and we'll see whether we can get Rowan back for the slides at the end. So, as you know, lockdown started on the 23rd of March 2020. Government's been giving guidance right, left and centre on a huge range of matters. In my view, not the best guidance on a lot of aspects of it, and I think it's guidance on working safely during the coronavirus period is fairly vague, bland, one size fits all. There's been two versions of the guidance for landlords and tenants. The first version came out on the 28th of March and it was updated about a week ago. So I've given you the link there to the updated version, slightly less apocalyptic than the first version, I think. And what the guidance says, to make it clear, there is no change to a landlord's obligations. Your repairing obligations haven't been suspended during the time of corona. You still have to carry on doing repairs. But it's not that easy, is it? There's no ban on visiting properties to carry out repairs, but can you actually get access? Do you really want to go and do that? Does the tenant really want you to go and do that as well? So if there's disrepair that started before coronavirus, in my view, damages will still run, but subject to what is a reasonable period of time. Rowan told you, of course, that you've got a reasonable period of time to carry out repairs. That will be longer when it's harder to do repairs. That's the general statement of the law. It's going to apply because of the coronavirus, because of lockdown. We know that some people are not able to have people come around to their property because they're shielding. So you can't expect the landlord to force their way in and expose them to coronavirus just in order to prevent the disrepair period running. And so the proviso there is that the landlord doesn't have to pay extra damages. It's going to vary from case to case. You can't have a kind of one-size-fits-all policy and say, well, we're not carrying out any repairs at all. You need to be thinking about what repairs you're going to carry out and for who. I've been asked a question about cases that you'd settled just before lockdown started and you were going to carry out repairs, and whether the people that you've made that settlement with can enforce those in court, and if so, what approach you should take. Well, my view is that you're going to have to assess each one of those on their merit, but generally speaking, where it was just bog standard, low-level disrepair, no obligation to carry out repairs, but where it's the more serious disrepair, then we should be thinking about trying to get in sooner rather than later. I mean, this is what the guidance says. We understand current restrictions may obstruct some routine matters, but we expect landlords to make every effort. Those living with serious hazards that a landlord has failed to remedy should still be assured of local authority support. This is talking to local authorities about enforcing against private landlords. But landlords should also know they should not be unfairly penalised where COVID-19 restrictions may have prevented them from meeting some routine obligations. Now, the first version of the guidance said that you should be doing urgent health and safety issues, which are matters that will affect your tenant's ability to live safely and maintain their mental and physical health in the property. Leaking roof, other problems with the fabric of the building, broken boilers, so there's no heating or hot water, plumbing, so you can't wash, toilets, and security critical issues. And also they mention disabled people on things that they are reliant on. So you have to think not just about what the disrepair is, but who the tenant is. Are they someone who's at increased risk of exposure to coronavirus, or are they at increased risk of exposure to the effects of prolonged disrepair? So they may fall into both of those categories, of course. If you've got someone who is got a lung disease, for example, you really don't want to expose those to COVID, but you really don't want to expose them to being in a damp property for a longer period of time. So you really have to think about these issues on an individual basis. So how are you going to do that? And it's not so easy when you've got a large population, of course. So what records do you have? And what is your system for flagging up your vulnerable tenants? How do you know who's sheltering? How do you know who's within those vulnerable categories? How do you sort of triage these? Who decides it? And one of the key things is to talk to the people that you're involved with, to talk to them about how they see the balance for them. What is the risk of not doing repairs as well? Are there some repairs that you want to insist on, perhaps because they're affecting other people in adjoining or communal properties? And in those circumstances, how do you actually gain access? Of course, we've now got section 9A7, as I mentioned, but the guidance says that no repair or maintenance work should be carried out in a household which is self-isolating or shielding, unless that work is to remedy a direct risk to the safety of the household. But then you have to think about what steps you need to take to ensure their safety. And an obvious one is asking the tenant to go maybe into the garden. It's great when it's been nice and sunny like it has been, but not when it's raining outside. How can you manage that? How can you reassure tenants that they're not going to be exposed? So you've got some direct risks, which are those which will affect the tenant's ability to live safely. And there is a level of seriousness and a level of risk. You've got to find that balance. Video inspections are something that a lot of people have asked questions about. And a lot of tenant solicitors are now suggesting that they can give you videos of the property. A picture speaks 1,000 words, but they don't always speak very cogently or fluently. Videos are susceptible to being manipulated, as are photographs. What you can do, of course, these days is get your tenant to go around with their mobile phone and video it for you. It may not be top quality. It may not be stuff that you would want to use in court. If the video is sufficient to put you on notice, however, that's when time runs. You have to take notice of things. And it's not, of course, as Rowan said earlier, up to the tenant to identify all the issues and why there is dampness in the property, for example. They have got to just put you on notice of what's actually happening. And of course, you are entitled to go into the property to carry out inspections. You may be able to work with the tenant so that they, for example, go in, leave the property or go into a different room within the property, perhaps one of the rooms that's not affected by disrepair in any way. Don't rule out video evidence is my view. It may be something that allows you to make decisions as to whether this is something you need to carry out repairs on at the moment, or whether it's something that you can put further down the list. But do think about levels of PPE, face masks, obviously, sanitising. Yeah, it's all common sense. You don't really need me to tell you about common sense, but you know, we do live in a country where people stockpiled bog roll and went to Durdle Door en masse before lockdown was even lifted, so we can't rely on everybody to have the same level of common sense as you and I do. So when you're carrying out repairs, think about decants. Okay, decants may well be something that we need to do more of if you're carrying out extensive repairs that are going to need people to be there over a period of days. I've put in there, please ensure properly documented. You have no idea how many cases I've had where people have just moved into another property, not signed up for anything, and then they stay there and go, ha ha, I'm staying now. Should they be asked to do a coronavirus test before they're moved? Well, you know, it depends where you're putting them in. If they're being moved into communal property, then a 14-day isolation period may be required. But one thing you can do is assign a specific team to a property, keep them within a bubble, make sure that you don't get people sort of coming and going each day, a different set of people, exposing the tenant to a whole new set of. See, it's not just the person that's going in there, it's the people that they've been exposed to. It's the chain of exposure. So if you've got a bubble team who work together on one property, that may be sufficient. Again, depending on the case, depending on the level required in each case. Ensure that your contractors are properly trained, properly equipped, and check that your tenant really does want work contractors, I should say, not just workmen, of course, going in, not just a letter before action from a solicitor. Some of the solicitors get the initial instructions and then seem to steamroll over and say, yes, we want people in. Do ensure that they have checked with the tenant that they do want people in at this moment in time, that they haven't got any new issues that increase the level of risk. Keep records to evidence your decisions as to why you're not going in at this particular moment in time. And think about physically, how are you going to get in? The tenant comes to the door, how are you going to get in through the door? Most doors are not 2 meters wide, corridors, things like that. So ask the tenant to move in, then the contractors can move in, ask them to leave internal doors open. There's guidance here for people looking around houses when they're going to buy a house. All that kind of thing gives you helpful hints. And ask a tenant in advance to describe their needs and to tell you how they propose to do that. And generally speaking, keep your tenants informed of what the timescales are now for repairs. We understand that there's going to be a backlog, and the court will give some credit for a reasonable period of time being extended in these circumstances, but it's not going to go on forever. But manage expectations, keep records, keep people up to date. Compelling access, not so easy at the moment, not that easy to take people to court because there aren't any court, well, there's a few courts at the moment who just reopened. We are doing things remotely, we're doing videos, we're doing telephone hearings, we can do these things if you need assistance. And of course, at the moment, possession claims are being stayed, so you're not going to be getting disrepair counterclaims to possession claims. You would need an injunction to enforce the terms of the tenancy rather than saying suspended possession order, suspended on terms that you give access. But there is, as I say, section 9A7. But it's always better to work with the tenant, negotiate with them, explain what the problems are, explain how we can meet those problems, and record all refusals of access. Keep things clearly recorded, video if possible, and ensure that we are able to defend any claims later on that we just didn't do anything. Quantum of damages. As I said earlier, there are some cases where there is existing low-level disrepair. You can't carry out those repairs. At the moment, you're not expected to carry out repairs, and so the landlord's obligation is kind of in suspense, and so you're going to get a low level of damages. But in some cases, the serious ones, being in lockdown, you can't get out, you can't get away from the mold and the damp. It's going to increase the stress that you're feeling. It's going to be horrible. And so quantum may be even higher than it normally would be. You could argue zero, access refused, however reasonable a refusal was. So you've got a tenant who says, you can't come in and do the repairs because I'm shielding. You as a landlord say, okay, that's fine, we won't force you. So at that stage, probably damages for disrepair will be zero because a landlord can't be expected to do repairs against the tenant's will where you've got a reasonable refusal of access. The guidance also gives advice to tenants. First advice is keep paying your rent. There is no rent holiday. And also you should still allow routine inspections such as gas safety checks unless you are actually shielding. The landlord will have a defence to those if they could show they couldn't carry out the annual inspection and they carried out, took reasonable steps to do so. So when we're talking about litigation, we are of course talking about the pre-action protocol. And Rowan, are you now able to speak to us? Rowan, we're still having difficulty hearing from you. So I'll just answer a couple of questions. Need to decant tenants more often if social distancing restrictions are in place for the foreseeable future. Yes, I think we are more likely to have to need to decant tenants in order to carry out responsibly the repairs that a landlord is required to do. And where a schedule of works hasn't been provided to the tenant and the landlord is forcing access, is that a reasonable ground for the tenant to refuse access? Well, no, I don't think that is a reasonable ground. The landlord is entitled to access to prepare a schedule of works and can't be expected to tell the tenant exactly what's being done in advance, has to be expected to react to what they find on the ground. So, Karma, on the soundproofing, the cost of rectifying the issues, yes, because what you're talking about there is the age and character of the property. When you talk about retrofitting soundproofing, sometimes absolutely impossible to do so without almost destroying the character of the entire flat and making it almost uninhabitable. So yes, limited things to do. Okay, so let me just take over from Rowan and look at the pre-action protocol. It's now up to date. It used to be the pre-action protocol for disrepair claims. It's now housing conditions claims because it's updated to include fitness for human habitation. It doesn't apply to counterclaims and set-offs to possession claims, and it gives you a list of things that it covers, including ADR. And one thing I would like to emphasise is the need for us all the more to consider ADR now, alternative dispute resolution. There's going to be a massive backlog, not just of repairs, but in the courts. We're not going to be able to clear claims like this easily. So please consider mediation, dispute resolution of various types, and perhaps submitting it to a barrister for binding arbitration. Just an idea that you might like to instruct me on. The annex gives you useful template letters that you can use. And the idea of the the Ombudsman's scheme is another way of dealing with matters without going to court. So the letter of claim should be provided as soon as possible, and tenants should follow up an early notification letter with a detailed letter of claim setting out full details, requesting disclosure. None of this is particularly new from the existing protocol. Landlords should provide a schedule of intended works. As I said earlier, that's not an excuse if they don't do that for refusing access. That would be, in my view, something that the tenant would be unreasonable in refusing. Encourages the use of a single joint expert if necessary, and there are various experts out there who are very useful at providing a balanced view of the works that are required for the property. Inspection should take place within 20 working days. Please note it's working days, not 20 days of the landlord's response. That, of course, is going to have to be subject to access in the time of coronavirus and subject to any arrangements that have to be made. I wouldn't expect a tenant would need to be decanted in order just for an inspection, but they should be perhaps asked to leave the property if necessary. Failure to comply with the pre-action protocol is just something that the court will consider when determining what cost order is appropriate. And you may have to think about the costs of settling a claim where it's settled without litigation, but it was justified. So you can alter deadlines by agreement between the parties. This is the exact time when you should be thinking about doing that. You can act more speedily, but at the moment, of course, that is not likely to be the case. Limitation. Please, if you are extending limitation periods, think about that proactively, but make sure that you record exactly what is being agreed between you. Please ensure that you're not waiving limitation altogether, otherwise you could end up with a 12-year claim. But at the moment, as you know, all possession proceedings brought under CPR Part 55 have been stayed. That was originally until the 25th of June. It's very recently been extended until the 12th of August 2020. That's all possession proceedings, but that means that you're not going to have new proceedings underway that have got a disrepair counterclaim to them. The one thing that you can do, that you can get before the court, is agreed directions. And you can agree a set of directions, for example, for the exchange of witness statements, standard directions, send those to the court so you can make progress on a possession claim that has a disrepair counterclaim despite the stay. This also applies to appeals against possession orders. Even if it's the tenant's appeal and they don't want to stay, everything is stayed. Right, so let's just have a quick look at what else we've got. Leak in the pipework under the floorboards. Landlord has to lift the laminate flooring that the tenants put down. Yes, I'm afraid the landlord has to pay to put new flooring back if they can't reinstate it as before, because it's the consequence of your breach, your disrepair. Yeah, and then that's another good suggestion from Tokyo Jikutu. Is the tenant or somebody they live with undertaking the repair a good option to attend to something routine or minor by agreement? Yes, if the tenant feels that they can do small repairs, not just during the coronavirus time, but generally speaking, this is something that you can agree and encourage. You can provide the materials for them to do that. As you say, you do have to check the workmanship, and that again is something that you can get them to do. Send you a photograph on their mobile phone, do them a video, and it is something that is a really sensible way forward for cooperation between landlords and tenants. Right, yes, I've been asked about hoarders and other people with various issues, mental health issues. Please do not forget the issue of capacity and getting care, getting social services involved. If your defendant or your claimant in a disrepair claim lacks capacity, that's something that you should bear in mind in litigation, and you should be thinking about whether hoarding is related to some kind of mental health problems. You may need to be proactive and flexible as a local authority or as a social landlord in meeting them rather than treating them as culpable for this. So the landlord is willing to undertake the required works, can't do that because of failure to declutter. What's the reason for the refusal to declutter? Is it an inability to do so because of mental health problems? Are there other mental health problems where you should be making a referral to social services? Joint working between social services and the landlord is the best way forward in those. In terms of damages there, you are again looking at a mitigation of the, it's whether there's a reasonable period of time to carry out repairs has expired in relation to reasonable period of time is assessed in relation to all the conditions that apply at the time. So it's things like coronavirus, but it's also things like the tenant's mental health. It's things like the weather and things like that. So a reasonable period of time. How long is a piece of string? In this case, your piece of string is longer because of the tenant's failure to cooperate. So I hope that answers that. Did I hear Rowan say that steps leading to the property are not part of the exterior? I think if you did, he was wrong on that. I hope you didn't hear him say that. In a disrepair claim, the council's surveyor has provided a report following inspection, and the claimant's solicitors rejected it as being not Part 35 compliant. Couldn't answer that without seeing it. But the fact that the council surveyor is employed by the council is not of itself a reason to reject that The case on that one is Lee and Leeds. So can a waiver from a tenant displace Section 11 obligations? That's an interesting one. I think I would have to say on that one it would depend. It would depend on the circumstances, depend on the extent of the waiver. I think rather than displacing Section 11 obligations, I would say it reduces damages possibly to zero. Dr. Pavlovsky points out the operation of Section 11 can be excluded by an application to the court under Section 12(2), something I've never seen done in practice. That's a really interesting one to try. So is bath sealant part of the apparatus? No, it's not. Bath sealant is part of the tenant's jobs, one of the little tenant-like jobs around the house that a tenant would be expected to do. So that's my view on that one. 23rd of August rather than 12th of August. What did I say? I think you're right there. Okay, now it is now 3:05, so you've had the full hour. We've had lots of questions. If you have any further questions following up on this, please do feel free to send me or Rowan an email. We've got the email addresses. Whoops, sorry, I pressed the wrong button there. Got email addresses at the end of the slides. These slides will be available on our COVID-19 unit on our website, along with all the slides and recordings from all the previous sessions as well. So we've got tenancies, capacity, care proceedings, antisocial behaviour, everything you wanted to know about housing law in the time of coronavirus is going to be up there on our website. Go and download those. Feel free to send us any further queries there. If they go beyond little questions, feel free to send us a brief. And if you have got anything going up to the Court of Appeal on Section 9A, fitness for human habitation, I'd be delighted to be instructed by you. I can't wait to get my teeth stuck into that and try and explain to the Court of Appeal what fitness for human habitation means in this day and age. So I hope that's been of interest to you all. Thank you all for your participation. I just wish I could speak to you all in person. But as it is, it's just nice to know that you're all out there listening to us. And I'm sorry that Rowan's had to drop off. We'll try and get him back for future seminars. Thank you all and goodbye.